Good afternoon, everyone, and welcome. Our topic this afternoon, employee absences, restrictions, and accommodations, is one that causes our clients, and we certainly as their lawyers, much headache and consternation. I am Ann Radolinski, and I am joined this afternoon by my colleague, Ashley Thronson. Both of us are members of our employment law team here at Fredrikson and Byron, and we are going to tackle this topic in such a way as to make sense out of all of the complexity. Our goal is to provide you with practical steps, a practical roadmap, if you were, for addressing and resolving employee absences, restrictions, and accommodation issues that will allow you to both comply with applicable federal and state law, but also allow you to meet business objectives, hopefully. So going to our agenda, we will begin with a very high-level outline of some of the major federal law that comes into play in this area. We will then quickly move to a discussion of a series of factual scenarios involving employee absences, restrictions, and accommodations drawn from real-life situations that our clients have actually presented to us. Finally, at the back of our PowerPoint, you will find an outline, a practical map for your future reference that lays out steps to be taken where the FMLA applies, where the FMLA does not apply, where job restrictions are at play, where worker comp is at play, and when there are pregnancy issues. In addition, you have been provided with a number of links. You've been provided with a series of links that are the DOL recommended forms for use when an employee has a serious health condition that requires a family and medical leave. We have also provided you a link for your future reference to an EEOC publication, a recent publication that came out in May of 2016, which sets forth the EEOC's view of best practices for approaching employee leaves and accommodations. We will have some time at the end for questions. If there are any questions that we are not able to answer due to the time allotted and you would like a follow-up call from Ashley or I, please indicate that when you send your question so that we may be in touch with you. If you have not already received instructions about how to give us a question, down at the bottom of your screen there should be an icon, a Q&A icon. You hover over it, click on it, and then it should be fairly user-friendly. You type in your question and you send it to us and we will receive it. This is one of the most challenging areas for employers and their counsel, and it's challenging for a number of reasons. It's challenging from the human perspective, simply because people's lives in the span of a work career are not always straightforward and smooth. Life tends to be complicated, and depending on where employees are in their life cycle and in their careers, they may be faced with health and other hurdles which will necessarily spill over into the workplace and interfere either temporarily or on a sustained basis with their ability to perform their job. Second, and equally as important, this is a challenging area because there are a myriad of federal and state laws that come into play when an employer is addressing employee absences, job restrictions, and accommodations. These laws are overlapping and they are sometimes conflicting in their obligations and requirements, making this an even more complex area. In addition, as we all know, these laws are always changing, and we can expect more changes as we move forward with the new administration in the months and years ahead. And also we can expect more changes on a state level that will affect this area. We will continue to keep our clients informed as these changes occur. This area is also complex because in addition to the myriad federal and state laws, employers, when making decisions in this area, need to keep track and manage a wide array of benefits. And in some instances, there are benefits such as in California, afforded to employees by government regulation. In others, the benefits are solely employer provided, but it is an area that must be handled appropriately along with the other decisions in this area. And in addition, there are often employer policies and procedures that need to be referenced. Sometimes these policies and procedures may feel as if they are hindering rather than assisting the employer in the process, but nevertheless, these are things that must be reviewed. We will begin with a high-level outline of 3 major federal laws that come into play in this area to provide a legal context for our discussion of the employee scenarios. Ashley will cover the Federal Family and Medical Leave Act and the Federal Pregnancy Leave Act.
Thank you, Anne. So the first major federal law that comes into play in these types of scenarios is the Federal Family and Medical Leave Act. And big picture, under this act, it provides 12 weeks of unpaid job-protected leave for a series of events, including birth, adoption, placement of a child, or the employee's or the employee's spouse or child or parent's serious health condition. And as I mentioned, it is a job-protected leave. So the process involved under this law would involve the employee first notifying the employer of the need for leave, and then within 5 days of that notification, the employer must fill out the notice of eligibility, which is one of the attached forms that you received, which is the WH-381, and that will notify the employee of whether or not they're actually eligible to take family medical leave. And then the employer can request certification of the serious health condition, and then the employer also has to designate the leave as FMLA leave. Otherwise, the employee's leave will not count against entitlement under the FMLA. So in order for an employee to take leave under the Family Medical Leave Act, it really is a low threshold. The employee has to have worked for the employer for 12 months and taken or had worked 1,250 hours in that time. And then unless it involves the birth of a child or a placement of a child, the employee has to have suffered a serious health condition. The law also covers limited access to medical and mental health information that pretty much is limited to the form or the information that is provided on the forms from the employees, most notably that request for certification. And then there's also confines on confidentiality obligations as well. The second major federal law that comes into play in these situations is the Pregnancy Discrimination Act, which is part of Title VII. And Title VII prohibits discrimination based on pregnancy, childbirth, medical conditions related to pregnancy and childbirth. And as a part of that, it involves treating pregnant employees just as similarly situated other employees. For example, employees who may have been injured or on workers' comp benefits. And so that would involve accommodating pregnant employees either through leave or other types of job restrictions. Now, depending on the state in which the employer is located, there are also state-specific pregnancy discrimination acts. For instance, in Minnesota, there's the Women's Economic Security Act, which also provides for 12 weeks of unpaid leave and has mandatory reasonable accommodations, including rest breaks, seating arrangements, and lifting restrictions of 20 pounds.
In addition to the Federal Family and Medical Leave Act and the Federal Pregnancy Discrimination Act, which is a part of Title VII, the federal law that repeatedly comes into play in this area is, of course, the Americans with Disabilities Act. The ADA is the most comprehensive and complex law affecting employer decisions with respect to employee absences, restrictions, and accommodations. The ADA has extremely broad coverage, and as we all know, in particular since the 2009 amendments to the statutory scheme, challenges to coverage under this law are extremely difficult. As a result, and as a practical matter, employers can pretty much assume that most physical or mental impairments are going to be covered by the ADA. The ADA is a unique statute in that it not only prohibits discrimination against folks that have physical or mental impairments, it also imposes an affirmative duty on employers to provide reasonable accommodation to the disabled worker so that that person can continue in his or her employment and perform the essential functions of the job. The ADA requires the employer to engage in what is referred to as an interactive process with the worker who has a physical or mental impairment to determine the nature of the impairment, how it affects job performance, and most importantly, what steps may be taken by the employer to provide the worker with reasonable accommodations so that the worker can continue in the job. The ADA also imposes, as most federal employment laws and as most parallel state employment laws, the ADA imposes on employers confidentiality obligations with respect to employee information. Under the ADA, it's medical and mental health information that is obtained during the interactive process. What this means is that in most instances, medical and mental health information on an individual should not be shared with the employee's manager or supervisor. The manager or supervisor, of course, has to know that the employee is not going to be at work and how long they're not going to be at work. They will need to know about hours and other job restrictions necessary to allow the employee to perform the job, but they should not be privy to medical and mental health information on the employee. If the employee chooses to share it, that's another matter. Improper disclosure of such information is a separate violation of the ADA, and there are similar provisions under other federal and state laws. Reasonable accommodation can take many, many forms, as we all know, and there are a number of listed examples of reasonable accommodations on the screen before you, but this is not an all-inclusive list. There are, of course, limits to reasonable accommodation. These limits, however, are going to depend on the individual circumstances of the employee. For instance, depending on the totality of the circumstances, the employer may at some point be able to determine that the individual, even with reasonable accommodation, cannot perform the essential functions of the position. Similarly, depending on the circumstances, the employer may be able to determine that even with reasonable accommodation, the individual poses a direct safety threat to themselves or to others. In addition, there are limits to reasonable accommodation if the accommodation proposed causes an undue hardship to the employer. The important thing to remember, though, about undue hardship is that it has a very, very high threshold. The factors considered in determining whether a particular accommodation creates an undue hardship are listed on the screen. The impact of these and other major federal laws must be considered together with state worker comp laws, state FMLA laws, state pregnancy laws, other state leave laws, state human rights acts. All of this must be considered in evaluating the employer's obligation and approach to the employee's individual circumstances. With that 30,000 feet above sea level view of some of the major federal laws, just to give us context, let's move on to our employee scenarios. Ashley?
So under the first scenario, we have Mary, who is a long-term employee in the finance area. Her performance has been slipping for the last 6 months, and initially the manager was sympathetic, but now has become frustrated. So the manager meets with Mary regarding the performance, and Mary then calls in sick for a week and requests leave. The manager now wants to transition Mary out and into another department. So Anne, let me ask you this. What is the primary law that comes into play here, and what is the recommended approach an employer should take in this scenario?
Well, there are a number of laws that come into play here, but the major one that comes to mind is the Federal Family and Medical Leave Act. This example is meant to illustrate, in part, the approach that an employer would take where the FMLA applies, and in contrast, where the FMLA might not apply. So let's just assume in this instance that Mary, when she called into HR or whoever she spoke to, said that she needs leave because she's had some blood pressure issues. Her physician is sending her in for tests for her heart to see if there are any heart issues. She's had fainting spells, and she's going to go through a number of tests to determine next steps. Again, these examples come from real life situations. So in that instance, we already have enough information to know that the Family and Medical Leave Act probably does apply to Mary's situation. In addition, she probably does have a serious health condition as defined under the FMLA, because as Ashley has mentioned, the threshold for serious health condition under the FMLA is not that high. She also is a long-term employee. She's a full-time employee, so we will assume that she's met the hours and other requirements. So what the employer would need to do here is to go through the process that Ashley has described, get the appropriate forms to Mary, and in the end, we will assume that Mary does qualify for FMLA. You would follow the procedures under the FMLA, and this is job protected leave. You should also keep in mind, of course, depending on which state Mary is operating in, that you may have state FMLA procedures to keep in mind. Examples of states that have their own FMLA include California, Wisconsin, and other states. In most instances, the state FMLA will run concurrently with the federal FMLA, but there are often additional record keeping and other processes that must be followed. One side note, if you have a third party, another company, managing your FMLA for you, and the same applies to short-term disability actually. Note that it's the employer's obligation, with respect to the FMLA anyway, it's the employer's obligation, not the third-party administrator's obligation, to make sure that the Family and Medical Leave Act is administered appropriately. I say this because in the last year I have had a number of clients who have had situations where the third-party administrator determined that FMLA was not available to the employee. They relied on that then to their detriment, when in reality the FMLA leave should have been granted. So what if the FMLA does not apply to this situation? Let's say that Mary has not been with the company for very long. Let's say that she's only been there 6 months. She doesn't meet the 12-month requirement for eligibility. And let's say that she doesn't meet eligibility under any state law. Are we able to move forward? The manager in this situation wants Mary transitioned out or moved to another department. He's got work he's got to get done. His frustration is absolutely understandable. But what needs to happen in this process? Well, if we want to avoid a big legal mess, we do need to go through a few more steps here, even if Family and Medical Leave Act does not apply. The Americans with Disabilities Act and parallel state law protecting against discrimination based on disability and requiring reasonable accommodation and the interactive process comes into play. So what does the interactive process look like in this scenario? The interactive process that I'm going to describe has 4 or 5 steps, and these steps in large part can be followed in most situations, whether the situation is a job restriction that needs to be assessed that's based on a physical or mental impairment, or a leave that needs to be assessed based on that basis. So I'll just walk through it with you. And again, at the back of your materials, you have our outline of what we've called the practical roadmap for your future reference. But the first thing to do is to meet with the employee, either by phone or in person, depending on the circumstances. Here, Mary's already on leave, so it would be by phone. In our circumstance, we've already gotten a bit of information from Mary. You would want to have a follow-up phone call with her, getting more information from her perspective about what's creating the absence, how long the absence is expected to be, etc. In that phone call or meeting, you would explain to her that the company is going to need further information from her treating physician or healthcare provider to determine the length of the leave, the reason for the leave, and other details so that both she and the company can make appropriate decisions and accommodations. The third step would be to confirm in a letter or a memo or an email to the employee, whatever your process is, the substance of your discussion with her in terms of needing further information, etc., and to include a form or a separate letter that she would bring to her physician that would have specific questions regarding the requested leave. If you do not have forms, sample forms and communications in your system at this point, or if you haven't had your attorney review those recently, it's a good idea to consult with your attorney and make sure that you've got good forms and communication samples in place. One thing that we think is very important is to make sure that the form or the physician letter that you create is flexible enough so that it can be adjusted to meet the individual circumstances. The questions will not always be the same. You will not always need to know the breadth of information you might need to know in one situation that would not be necessary in another. The fourth step is that once the information is received, you review the information from a business and operational perspective, but you also review it in light of the employer's decided obligation to provide reasonable accommodation. The federal and state disability discrimination laws require the employer to engage in a good faith process to determine reasonable accommodation so that the employee can continue in the job. You meet with the employee to discuss the decision. You take into consideration any additional information the employee provides, and you ultimately document the decision, which would be in this instance, presumably that we would grant the requested leave to Mary. We assume initially the leave may be 1 or 2 months. If at any time, I list this as a fifth step, but it's a caution that we really stand behind. If at any time there is a decision not to grant a requested leave or to deny an accommodation, we urge you to consult with counsel and walk counsel through the process and the information to make sure that you're in good stead in case you have a legal challenge. As a side note on reasonable accommodation, even where the FMLA does not apply, it's good to keep in mind that if you've got a leave policy that limits non-FMLA leave to 30 days or 60 days or 90 days or some other set amount, that these kinds of policies are viewed to be in violation of the ADA. The statute trumps any employee policy. This is because the interactive process is supposed to be an individualized process, and what is reasonable in one circumstance might not be in another. Going to the next slide, Mary is granted the leave. The manager and coworkers find mistakes in her work during her absence. The department actually runs smoothly without her, and the manager wants to terminate or transition her out. Ashley, can the employer terminate Mary while she's on FMLA leave? Let's assume it's an FMLA leave. What is the employer's approach here?
Well, whether the employer can and whether the employer should terminate Mary are two very different questions here, and it certainly would not be recommended that the employer terminate Mary while she is on leave. As I mentioned earlier, FMLA is a job-protected leave, and so there is that presumption that if Mary's on leave and she's terminated, that it's because she took the leave. And so Mary will come to that conclusion, and the employer will have to fight an uphill battle if Mary brings a lawsuit showing good reason why she was terminated while on that leave. So I would say the employer should not terminate Mary while on that leave, particularly based simply on the fact that they had found mistakes and that they found that the department can run perhaps even better without her.
Absolutely. There are some extraordinary circumstances where we would feel comfortable with a termination decision while a person is on FMLA leave. One that comes to mind is a circumstance I've had in the last several years where the person was on FMLA leave and we discovered that she had engaged in embezzlement during her employment. We did a thorough investigation and we're comfortable in terminating in that instance. There are other circumstances where you can, but as Ashley indicates, it is extremely risky, and caution again that if you are going to terminate during a protected leave, please consult with your attorney.
So as this situation progresses, Mary now cannot return at the end of her FMLA leave. She has also exhausted her paid time off and is receiving short-term disability benefits. The manager continues to be frustrated and continues to want to terminate. So Anne, what is the approach here?
So she's exhausted her FMLA, so we need not provide her any additional leave under the FMLA, and she cannot return to work at the end of her leave. We're going to assume that she's explained that it's because she's continuing to have health issues. Even where the FMLA has been complied with and full FMLA leave has been given under federal and state law, the Americans with Disabilities Act still comes into play. We need to go through the interactive process to evaluate whether it is reasonable to provide additional leave. And it is the same process that I outlined in the initial discussion of this hypothetical. You meet with the employee. Here again, it would be by phone, obtain further information from her perspective, explain to the employee that the company will need further information from her treating physician or provider to determine the need for additional leave, the reason for additional leave, and other appropriate information to determine what accommodations can be made. You confirm that in a letter or memo or email according to your processes and include a form or a letter that she is to take to her physician with specific questions regarding the requested extended leave. Once the information is obtained from the provider, you review it from a business and operational perspective, also with the idea in mind that the law is going to want the employer to go through a good faith effort to allow this person to maintain their job. You document the decision and you communicate it with the employee. And of course the fifth step, and always from our perspective one of the more important ones, if the decision is to not grant the leave or to deny some other accommodation that she has requested, please consult with counsel before doing so to make sure that your documentation and everything is in good stead for a challenge. I have a question for you, Ashley. Let's say that the employer had a policy that they only granted leave through the end of an FMLA, and they didn't, as a matter of policy, grant additional leave, and they terminated Mary at this point. What would be the potential consequences to the employer?
Well, and as you mentioned, the law does trump any policies, and the law says that you have to continue to engage in that interactive process. And if the employer refuses to do so and refuses to accommodate when a reasonable accommodation is available, certainly they open themselves up to a lawsuit, either under any of these federal laws that we've discussed, the FMLA, ADA, in addition to any of the state equivalent laws. And in that circumstance, they may find themselves liable for the employee's wages and benefits, lost wages and benefits from the time of the denial of the accommodation through trial, as well as attorney's fees. Some laws, like the ADA, provide for punitive damages, as well as compensation for pain and suffering and other types of emotional distress. And as well as, I mentioned attorney's fees for both the employee that might prevail as well as the attorney's fees that the employer will incur in defending the action. So it really becomes a very costly endeavor when mistakes are made under these laws.
So just all the more reason why we advise that steps be followed and documentation be taken seriously in this area, as in other areas, as we all know. Going to our next slide, let's say that in our scenario, Mary is granted a 2-month personal leave, an extension to her FMLA. But then at the end of that personal leave, 2-month personal leave, she still cannot return to work because of health reasons. This is a story that I'm sure many of you have heard before and gone through. She's exhausted, let's say she's exhausted her STD benefits at this point. The manager now is becoming apoplectic. He's reaching the breaking point, which is understandable. He wants to move her out of this department or to terminate her. Ashley, what are the laws that come into play here, and what is the approach that we would recommend?
Well, here, since FMLA has been exhausted, we are still in ADA land, even though there's an exhaustion of personal leave and of short-term disability benefits. The ADA still applies, and as you mentioned, and although the manager's frustration is definitely understandable, we still recommend you walk through the steps of the interactive process before making any determination as to termination or refusal to accommodate. So you meet with the employee and you see, get information from the employee to see what is the perspective of if the employee can come back to work, what the limitations are, and you continue to engage in that interactive process, see if there is any sort of accommodation that is available and that is reasonable. You document that, as Anne had mentioned in previous scenarios, and then I would definitely recommend still consulting with counsel in making that final decision.
So the question we always get, and it's a fair and important question, is, well, Anne, Ashley, what is the limit on the employer's obligation to accommodate here? What is the limit on providing leave? And that really is going to depend on the individual circumstance. That doesn't mean we can't give you an answer. So if you were to call either of us and walk us through the scenario and provide us with the documentation to date, we could give you advice on whether, you know, we're ready at the end of the 2-month extended leave to say that no, we can't accommodate any further leave or not. What are some of the considerations? Well, one of the major considerations in this scenario is, okay, so she finished her 2-month extended personal leave. She can't come back to work, but we don't know when she can come back to work. It might well be, when we obtain further information through her from her treating physician, that she can come back to work in 2 weeks. If we were to terminate at this point without seeking out that information, we would be in a very difficult position if she were to file a disability lack of reasonable accommodation charge, because it would be hard to show that an additional 2 weeks of leave was an undue hardship under those various criteria. However, there are circumstances, which I'm sure you all have seen, where the individual is perpetually given an extension of 8 weeks. You know, the doctor says, well, she can't come back for 8 weeks, but I'll evaluate in another 8 weeks, and I'll evaluate in another 8 weeks. At some point, we are comfortable with deciding that her absence renders her unable to meet the essential functions of the job, which is being at the job at some point. And also that it would be an undue hardship. But part of what gets us there, is a very well-crafted letter or form that is given to the physician with very specific questions, so that the physician presumably will get to the point where they will tell us in so many words that I cannot determine a return to work date for Mary. She is unable to return for the indefinite future. One thing that is clear under the Americans with Disabilities Act and most state law is that an employer is not required to keep a job open indefinitely. So let's move to our next scenario, which is a pregnancy situation, also taken from a real-life situation. One moment, please. We're having a little bit of technical difficulty getting to our pregnancy scenario. Thank you.
Okay, so in scenario number 2, we have Simone. And Simone was just hired into a department that is very desperate for her help. Upon being hired and upon starting, she informs her supervisor that she is pregnant and needs intermittent leave due to her complications. Her supervisor is unhappy with the performance that she has had so far and wants to terminate. So, Anne, what is the primary law that comes into play in this scenario, and how would you recommend the employer approach it?
I'd like to recognize, first of all, that we understand the frustration in these situations. And again, these are taken from real life situations. The thought in the back of everybody's mind in this situation was, for gosh sakes, this person knew when they applied for the job, and certainly after they interviewed for it, how busy this department was, how desperately they needed somebody physically there to do this job. She already knew she was pregnant. Why didn't she self-select out? Why didn't she let us know she was pregnant? Why didn't she let us put her in a different job? And of course, unfortunately, or whatever, fortunately under the law, employers are not allowed to ask questions in the interview process about pregnancy, and applicants are not required to provide that information. So our scenario is what it is, and I'm sure many of you have been faced with a similar one. In our particular scenario, the Federal Family and Medical Leave Act, there's a parenting leave provision, of course, under the Federal Family and Medical Leave Act that would apply if she was eligible, but she is not eligible because she just was hired. She doesn't have the requisite 12 months of employment. State law, however, must be considered. There may be, and there are, depending on the state you're in. For instance, California has laws that would come into play here. Iowa has laws that would come into play here. But there are state laws that come into play that would require us to provide a leave, even where the Federal Family and Medical Leave Act would not apply. Our own Minnesota here, where Ashley and I are physically based, Pregnancy and Parenting Leave Act would not apply, even in its extended form, because she has not met the 12-month employment requirement. If state law does not come into play, and we already know that the Federal Family and Medical Leave Act does not apply to our situation, can we just, tell Simone this is not working out, or move her to a different job, or take other employment action? Our analysis is still not completed because we have that Federal Pregnancy Discrimination Act, and under virtually every state human rights law, there are parallel protections for pregnancy and discrimination based on pregnancy that come into play. In addition, pregnancy in and of itself is not a disability, but complications relating to pregnancy may be. And in our particular situation, she's indicating that there are complications due to her pregnancy. The ADA may certainly come into play. In the end, if there is no state law that requires us to provide the intermittent leave, the employer is best served by engaging in the same 5-step interactive process that we've talked about, meeting with the employee, obtaining information, explaining that we need further information from the treating physician, confirming it in a memo, providing the form or letter to take to the physician or healthcare provider, and evaluating that information appropriately upon receipt, keeping in mind that this employee has protections both under the Federal Pregnancy Discrimination Act, the state human rights laws, and also potentially the Americans with Disabilities Act. We'll move to situation number 2 with this same employee. Simone informs the supervisor that she has lifting restrictions, needs more frequent breaks because of her pregnancy. The concerns with her performance continue. The supervisor says he cannot accommodate and wants to terminate. Ashley, what are the laws that come into play here, and what is the employer's best approach?
Well, under the Americans with Disability Act, pregnancy in and of itself is not a disability, but pregnancy-related complications can make the employee fall within the definition of being disabled. Additionally, there are state laws that come into effect as well, including the Minnesota Women's Economic Security Act that I had mentioned earlier. So under the ADA approach, which would apply to all employers regardless of which state you are operating in, the employer should follow the same framework that we've been talking about and laying out in past examples. They should meet with Simone to see what exactly her restrictions are and how they can accommodate them, get additional information from her doctor so that they can make a further informed decision, document all of that, and make an informed decision based upon all of that information that Simone and her doctor have provided. Additionally, if in Minnesota, under the Women's Economic Security Act, the employer, if they have at least 21 employees, automatically has to accommodate the lifting restrictions and the more frequent rest breaks.
How should the company handle the performance concerns? Do we just ignore those because she's protected under so many laws? What should we do there?
So the employer should not simply ignore the performance concerns because that could end up backfiring as well. Rather, the employer should treat the employee ignoring the pregnancy altogether in terms of performance. So treat her as if they would any other employee, address the performance issues, talk to her about them, but certainly consult counsel before taking any sort of adverse acts such as suspension or termination, those sorts of things.
Absolutely. One of the things that tends to happen in these circumstances, and again, very understandably, is the supervisor is just immobilized, doesn't want to deal with the performance concerns because he's worried or she's worried about a mishap in dealing with this employee. We run into this all the time. But in these situations, it is, as Ashley has mentioned, it's very, very important to address the performance concerns. The performance concerns are separate and apart from any leave rights or job restriction rights or other rights that this employee may have under applicable law. So you would document them just as you would any other performance concern and address them just as you any other performance concern.
So moving on to the final situation involving Simone, her performance does improve, and she informs her supervisor that she now needs a 12-week leave for the birth of her child due to family circumstances. The leave is to begin 6 months after she was hired. So, and is she entitled to leave under either federal or state law?
She, depending on what state she's in, the answer would be different, of course. But under the Federal Family and Medical Leave Act, she would not be entitled to leave because she hasn't met the 12-month work requirement, and she may not meet other requirements in addition. But under state law, depending on what state you're in, there are leave rights in this instance. For instance, two examples are California and Iowa, so you definitely need to look to state law. If you're in a state such as Minnesota, where you either don't have a state pregnancy leave law that applies or the person is not eligible for leave under the law because of length of service, you still have to, your analysis still has not ended. So if we were looking at this under Minnesota law, just to give an example, under our Minnesota Pregnancy and Parenting Leave Act, she would not yet qualify for leave because of length of service. She has less than 12 months. But that doesn't end our analysis under even state law. The Federal Pregnancy Discrimination Act comes into play, as well as the parallel state protections for pregnant workers. In order to avoid legal obligations, legal complications in this instance, we would highly advise that the employee be granted a leave for the birth of the child. A 12-week leave would not be required unless that's required under state law. As I mentioned, California and Iowa have their own pregnancy leave statutes, pregnancy leave provisions. But a 12-week leave, if state law doesn't require it, is not required. However, a minimum leave to at least cover the disability period of the pregnancy of the individual after birth should be granted in this instance. If you don't grant it, yes, there are some defenses, but in my view, you would end up with a judgment or an agency decision against you. The sympathy value for the individual is so high, and the individual would simply have to show that you had granted leave in an analogous situation, but you've denied it to this individual that needs leave for birth of a child. So typically, if there are no other guidances under your policies or under state law, the notion still is that a minimum of six weeks for a natural birth and 8 weeks for a C-section. But if the person has additional complications after the birth of the child that requires her to have an additional leave, you would need to engage in that same interactive process that we talked about in our other scenarios. Our next situation involves a bit of a worker compensation claim. So John has been employed for only 2 months, and I see that I wanted to emphasize the months here, 2 months. He is a sales employee, and he services major national accounts. This job requires 75% travel. He's injured while traveling on the job. He files a worker comp claim. The manager is beside himself or herself and wants to replace John. Ashley, what is the employer's recommended approach in this scenario?
Well, here, since John has only been employed for 2 months, he does not meet the threshold for the Family Medical Leave Act. But that does not mean that the employer is off the hook. As all of you should catch on by now, the ADA still applies even when the FMLA does not apply. And so the employer needs to engage in that interactive process. Here we'll assume that his injury affects his ability to work or affects his ability to travel. And as Ed mentioned, traveling composes 75% of his job duties, which there would be the assumption, though we'd have to look through the job description and evaluate whether or not that is an essential function of the job, but here it's probably safe to assume it is. And so the employer must walk through that process. They have to get information from the employee about the employee's disability. Here, again, it's an assumption, but if the employee was hurt and filed a work comp claim, that likely will meet the low threshold of disability under the ADA. And certainly the employee probably has already provided some information through their work comp claim, but it is important to still engage in that process, make sure that the employer has all of the information that they need from the employee and can seek additional information from the employee's doctor to make an informed decision, and follow those additional steps of documenting, communicating to the employee, and then making an informed decision, ideally with the assistance of counsel, whether or not to terminate or refuse to provide additional accommodations. But in this situation, termination probably would not be ideal, particularly without engaging in that interactive process to really see what the limitations are.
Now we are at the 3-month point. Let's say that John was granted a 3-month leave based on the information that you received from his provider. His provider had said, let's say, that he is not able to travel and has to be home-based for 3 months. We don't have home-based work for him because his job really is to travel and be in front of clients. So he's essentially been on leave for 3 months. The worker comp claim has been denied, and John can still not travel. He's not indicating when he can travel again. The manager really wants to terminate. The manager is having to do her own job and his. What is the employer's recommended approach in this scenario? Does the denial of the worker comp claim change the approach, Ashley?
No. So the employer should continue assessing it under the ADA as they would even if the workers' comp claim had not been denied. That denial has nothing to do with whether or not the employer must accommodate this employee. And so the employer should engage in those exact same steps, continue to evaluate the situation, continue to get the information from the employee, see if his disability or treatment or situation has changed. As Ann had mentioned in a previous scenario, see if the doctor has any indication of when he may be able to travel again, because if he can travel in a week, that's different than if who knows, when he might be able to travel again. So it all goes back to that 5-step interactive process of meeting with the employee, discussing the situation, getting more information, and basing the decision on the information received as well as the business objectives that need to be met as well.
In this particular scenario, because it does come from a real-life situation, the provider ultimately responded directly to one of our questions and indicated that the provider could not determine a return date for John, that the provider was taking the position that John could not travel for the indefinite future, and we were able to terminate that employment. We'll go to our last situation, which is also from a real-life situation, and I would imagine that some of you at least have faced it in some form over the years.
So in situation number 4, we have a long-term employee who's on a final warning, although the performance issues continue to persist. HR and the manager meet with the employee because they want to terminate him. The employee states that he has been diagnosed with a mental health condition that affects his performance, yet the manager still wants to proceed with the termination. So, Anne, can the employer move forward with the termination in this situation?
This is a very interesting situation, and the employer's decision here depends really on their tolerance for risk in defending human rights charges. Technically speaking, this decision to terminate was already made. We will assume in this scenario that the employer had no notice, indirect or direct notice, that this employee had a health condition that was affecting performance, that there had been documentation along the way, meetings with the employee about the performance, and the employee had never brought it up. So if the employer has a high tolerance for risk and does not wants to make a point of this and wants to try defending the human rights charge that is likely to come, there are legal arguments that can be made in this scenario. Now, what the agency will do with this will depend on all of the different facts, so it isn't without risk. In this particular scenario, the client decided to take the more conservative approach with the idea that, okay, we can slow the process down, go through the interactive process, get him back on a performance improvement plan, taking into consideration any job restrictions he has, and we will ultimately be able to terminate, and we will presumably be in a better place to win the human rights charge when it comes. So this is one of those situations where we would definitely ask you or urge you to consult with counsel before moving forward, but there are a number of options here for the employer. Ashley is going to make a couple of comments to wrap up our session for this afternoon, and then we are going to take questions. But I wanted to just make a few announcements. Our immigration team is hosting a webinar on the new I-9 form and compliance on January 24th. Our colleagues Lon Wynn and Deborah Schneider, both excellent presenters, will be presenting. And more information and a link to register can be found on our website, fredlaw.com. Go under events, and you will see that seminar listed, as well as other seminars that we have during the year.
So please take a look at the roadmap that we have provided for you. It lays out in more detail how to approach these scenarios, just as you've seen us apply them. But really the takeaway from today is there are a lot of complicated intersecting laws that affect employee restrictions, leaves, and needs for accommodation. It is a legal maze with many moving parts, but there is a very regimented approach that you can take that will help you through it. And the keys are communication with the employee and with the managers, and through the employee with the employee's doctors, as well as documenting everything that happens, whether it's performance or the interactive process, the decisions that you're making, the need to have more information. All that should be documented. So with that, we're going to use our last couple minutes to address some of the questions that we have received.
We may go over our time a little bit so that we can answer a number of these questions. For those of you who are not able to stay with us past 1 o'clock or choose not to, thank you very much for your time and attention. It's been our pleasure. I'm going to take a few of these questions and try to run through them so that you have answers as efficiently as possible. One question is, in Minnesota, the individual is correct that under the Minnesota Pregnancy and Parenting Leave Act, the individual has up to 12 weeks of leave. Does that include 12 weeks of FMLA too? I believe what the individual is asking, and it's a very good question, is the 12 weeks of leave under the Federal Family and Medical Leave, does that run concurrently with the Minnesota Pregnancy and Parenting Leave? In most instances, yes, but in some instances, it does not. So this would be a point you would want to seek you would have to provide me with a bit more information on the individual circumstances, and I could tell you. But the answer is, in most instances, the state and the federal law in Minnesota will run concurrently, but not in all instances. The next two questions come from two different people, but they relate to the same thing. The person is asking, what if we're a small business? We have only 5 employees, or how does this all impact small employers? Well, depending on what state you're in. Now, for instance, if you only have 5 employees, the Family and Medical Leave Act is not going to apply to you. The Federal Americans with Disabilities Act is not going to apply to you. There are a number of laws that may not apply to you, but the thing to keep in mind is, even if you're a small business, state human rights laws, which provide a lot of the same protections, may apply to you. For instance, in Minnesota, the State Human Rights Act kicks in with only 1 employee. So the reasonable accommodation and prohibition against disability discrimination requirements apply to small employers, and the pregnancy discrimination protections apply to small employers. So this is another question that if you have specific areas of law that you're interested in and want to know whether it applies to you as a small employer, just reach out to one of us in the days and weeks to come. The last question I'll take, and then I'll let Ashley start with her pile of questions. What if an employer is engaging in the interactive process, but the employee is not cooperating in the process following the exhaustion of the federal FMLA? That is an absolutely excellent question. So if the employer is engaging in a legitimate interactive process, and they're, for instance, seeking information through the employee from the employee's health care provider that is necessary to make an accommodation decision, and the employee, after multiple communications to the employee, multiple efforts, is not cooperating, that is a circumstance where we would be comfortable communicating to the employee, if you do not respond with the required information, with requested information by X date, we will presume that you do not wish to return to work. This is a scenario, however, please, please, please coordinate with counsel when doing this, because there are all sorts of moving parts, and there are all sorts of reasons why it would be a good decision to go down this road and say we're not going to engage, you're not cooperating, and we're going to assume that you don't want to come back to work. And there are all sorts of reasons why that would be the wrong decision. For instance, if the information we're requesting of the treating provider, if the conditions we're putting on the discussion of reasonable accommodation are not narrowly tailored to the information we really need, that would create risk factors for us. Ashley, you've got a bunch there.
Sure, so I'll try to run through as many here as we can in the next couple minutes. One question asks that if the manager's concern in some of these situations is staffing, can they hire a replacement at this point to fill the role? And here I would say yes with an asterisk. Yes, they can hire a replacement as long as it's understood that the replacement is temporary. Certainly the business has to tend to their business concerns, but at the same time, FMLA leave is job protected leave, so as soon as that employee who's on leave is able to return, then they are entitled to their job back or an equivalent. So yes, you can proceed with caution, but as long as it's a temporary replacement, there shouldn't be an issue. Another question points out that under the FMLA there are eligibility requirements, including that you have to work 12 months and 1,250 hours in order to be eligible. And this question asks whether there are similar eligibility requirements for an employee covered under the ADA, or whether the ADA applies as of day one. And that is true. Under the ADA, there are no sorts of you have to work so many hours or be employed for so long for the ADA to apply. At the same time, though, the ADA is very, very detailed in what constitutes a disability and whether or not someone is a qualified individual with a disability. So it's not just free reign. There are specific criteria that the employee does have to satisfy in order to get the protections of the ADA, but there are no sorts of time requirements or working hours in order to come within the protection of the ADA. Do you want to address a couple more?
I have a couple more here. This question, is it also risky to terminate an employee on intermittent FMLA leave? The answer is a resounding yes. All of the same risk factors come into play as with any other federal or state FMLA protected leave. So this would be a situation where if you are wanting to terminate the employee, for instance, because of performance reasons, reasons unrelated to the FMLA leave, it is a really good idea at that juncture to just have at least a brief conversation with your lawyer to make sure that that you've got everything in order to manage those risk factors. There are circumstances where you can terminate someone while they're on intermittent FMLA leave or a full time FMLA leave, but these are very fact-specific decisions that need to be made. Another question, do the processes change at all if the employee is part-time, 25 hours or less? What about if they've only been employed for a few months and have not formally requested a leave? Well, if the employee is part-time, depending on how many hours that they're working, so with the FMLA, the federal FMLA, you have to have worked 1,250 hours in the 12-month period that directly precedes the beginning of the leave. So the part-time employee may or may not meet that. I don't have a calculator here to do the math. I think they probably do, but I don't know. But even if the Federal Family and Medical Leave Act does not apply in a leave request situation, you've got the Americans with Disabilities Act, and this may be what this person is asking. The Americans with Disabilities Act's reasonable accommodation requirements apply from day one of employment. Actually, they apply before the person is employed. They apply in the applicant stage. And they apply no matter how many hours the person works. The second part of this question, what about if they've only been employed for a few months and have not formally requested leave? Well, being employed for only a few months would affect some leave laws, but it would not affect the Americans with Disabilities Act or most of the parallel state law disability discrimination reasonable accommodation protections. What if they haven't formally requested a leave? This is a very good question, and this is one of those very fact-specific situations. There are circumstances where even if an employee has not formally requested a leave, where the employer has enough information to know that the employee needs a leave because of a health condition or a mental health condition. So this would be a situation where you would want to check with your attorney, run them through what the facts are, and they can make that determination for you. Should we just take one more each? Or what would you
Sure.
like to
I
do?
was going to say I have a number that are asking whether the accommodation is reasonable. And here I would just say whether an accommodation is reasonable is a very fact-specific situation as outlined by the process of requesting additional information and engaging in the back and forth interactive process. So I think it probably would be best to follow up with these individual scenarios as to whether or not an accommodation may be reasonable in those certain circumstances.
I have two more questions, and then
Okay.
should we
Yep.
end? These are fairly quick. This individual indicates that they typically, if somebody is going to be absent for less than, I'm not sure, less than a month, they typically do not request additional information from a treating physician, but they currently have a situation where somebody needs 2 weeks off due to presumably health or mental health situation, and they're wanting to treat this situation differently. Does this create a risk? Yes, it does, because the notion of discrimination protection is that folks in similar situations should be treated similarly. However, this is one of those situations where I really urge you to reach out to your counsel, because there may be some circumstances that aren't listed here that would make my answer a bit different. And the last question that we have time for in the pile, we're a little bit over time anyway, is this person is asking, is it really advisable to send the documentation that I talked about in the interactive process by email? Wouldn't certified mail or regular correspondence by mail be more effective, because you would have some indication of a verification of receipt? You certainly can send things through regular mail, request return receipt. That is just fine. With respect to email, I know a lot of my clients do it. That's why I mentioned it. And I think we're fine because we normally, almost in all situations, there's a follow-up question from an employee to an email, so you know that they have received it. We thank you very much for your attention, and we would be happy to work through any of these issues with you. Our team would, as you face them in the months and years to come. Thank you.
Thank you.